Rules Committee will come to order, and welcome back to the Rules Committee for the afternoon of January 7th, 2018. Today, the Rules Committee will be considering S-139, the Fisa Amendments Reauthorization Act of 2017, as well as S-140, legislation to amend the White Mountain Apache Tribe Water Rights Qualification Act of 2010, to clarify the use of amounts of WMAT Settlement Fund. FISA Section 702 is a critical authority that allows the United States government to obtain the communications of foreigners outside the United States, including foreign terrorist threats. For example, FISA Section 702 allowed the government to track, find, and eliminate a top ISIS leader, Hashaf Imam, under FISA Section 702. But it was not bulk collection and cannot be used to target any person located inside the United States. And this legislation is a bipartisan, bicameral answer that was negotiated between not only committees of jurisdiction, but with the administration and through processes that deal with judicial empowerment. The committee will also consider legislation to restore rights, including leasing and waiver to Native American tribes. This legislative package clarifies the original intent of the Indian Long-Term Leasing Act and lends a way in protecting the sovereignty of Native American tribal governments. Tribal governments should possess the same inherent rights to self-governance as state and local governments. And I want to thank a member of our committee, the Honorable Tom Cole, for his work to ensure, before it came to the Rules Committee, our compliance to make sure that what we're doing here is important and fair to tribes and tribal leaders and members of tribes all across the United States of America, acknowledging that today we have members of those tribes who are present today at the Rules Committee. Tom, I want to thank you for your personal work in this effort. With that said, I'd like to welcome the first panel. However, before I do that, I will defer to the gentlewoman, the ranking member, but I would welcome from California the gentleman, Mr. Lamalfa, the gentleman from Indiana, Congressman Rokita, the gentleman from Virginia, Congressman Bobby Scott. Several weeks ago, we had Bobby Scott today at the Rules Committee, and I'm sure he is prepared to reclaim that title from Wisconsin, Congresswoman Moore. We're delighted that each of you are here today, and delighted not only that you've taken time to come to the Rules Committee to discuss this important legislation, but also to represent your constituents and your party about such important matters. So without objection, anything that you've brought in writing will be entered the record today. Today we have the awesome stenographer who is prepared and will want to properly complete the record, and so any help that you can give her in that effort will be appreciated. I defer now to the gentlewoman, my dear friend, the gentlewoman from Rochester, New York, the ranking member, Ms. Slaughter.
Thank you very much, Mr. Chair. I really appreciate it. I really want to reflect on the last year, since this is our first meeting of the new Congress. Mr. Chairman, you have always treated everybody here with respect and always polite and courteous, and we genuinely appreciate that. But the process itself was pretty awful. Record-breaking number of closed rules and bills jammed through the House without any time to analyze them, and often without committee action. I'm not speaking to any camera here, because my constituents are probably, if you were to ask them, would not be able to understand the closed rule. But I do want to speak to the members of this committee. We have a couple new members here who may think last year was normal, that that's how Rules Committee always operated or how it's supposed to, but I want to be clear that last year was not normal, so let's juxtapose last year with recent history. It was a record-smashing year for closed rules, 58 completely closed rules. To put that in context, we averaged 25 closed rules a year in the 4 years that we were in charge during the 110th and 111th Congress. 25 versus 58. last year was more than double our average. On top of that, this speaker is the first speaker since the invention of the open rule to never allow, in his leadership, a truly open rule. Last year, he didn't even allow a single modified open rule. So I really want that to sink in. 0 open rules, 0 modified rules, and more than twice as many closed rules as we did in the 4 years we were in charge. Most of your rules blocked all amendments, Democrat and Republicans. They didn't have an opportunity to do amendments either. So let me say that again, that most bills that come up here block all amendments. In total, the Rules Committee blocked 1,533 amendments from being considered on the House floor just last year. So here we are, beginning with a new Congress with a chance to start off on the right foot. Go back to regular order, offer truly open rules so that all members have the opportunity to at least to try to make improvements that they think are necessary to the bill. We can also ensure that bills go through the committee process, which I think is most important, and receive adequate consideration. And you can work across the aisle and finally pass real bipartisan compromises to reauthorize the CHIP program, providing health insurance for 9 million children, reauthorize community health centers that 9 million Americans rely on, bring the DREAM Act to the floor and protect the 122 Dreamers losing their protected status each and every day, 122. Address the opioid epidemic that's killing 91 Americans every day. Provide disaster relief for thousands of families still struggling from last year's devastating wildfires and hurricanes. Save the failing pension plans that cover hundreds of thousands of workers and retirees. And of course, work with us to raise the budget caps. Pass a full-year spending bill and avoid a government shutdown next week. And Mr. Chairman, we've talked about this before. It is a long list of priorities, bipartisan priorities, I believe. But the committee squandered precious time last year, abused the legislative process to push through purely partisan legislation that went through only with Republican consideration, like the tax bill. And we're off to a bad start in this Congress. Instead of working on any of the issues I just mentioned, one of today's rules will be a closed rule on another partisan bill. Is that really how we want to run the House of Representatives? Again, I just want to remind my colleagues new to the committee that this isn't how the Rules Committee is supposed to operate, and it has not operated this way in the past under both parties. So we hope that this will improve, but we're not too optimistic, and I ask that unanimous consent that what my statement and this chart illustrating what we have talked about be in the
Without
record.
objection, in the record.
Thank you, Mr. Chair.
Slaughter, thank you very much. In fact, for the visitors of the Rules Committee today, it is true that there has been regular discussion, not only about the activities of this committee, but also the results of this committee. Mrs. Slaughter, in fact, as you heard, provided factual basis without it being personal at all. She has been an awesome and very productive member of this committee. She has had regular content with me. We have an open conversation with each other. Sometimes I'm right and sometimes I'm wrong, but never has she taken any personal privilege that I would consider not to be correct. She and I both view that the members of Congress who come up to testify before the committee are entitled not only to their opinion, but a vigorous ability of this committee to be prepared to hear from them. I am not going to at this time, though I'm well prepared to offer some bit of substance that would allow those of you who have heard the facts of the case, but to hear some bit of justification to that, including congressional CRAs that were some 27 that were either yes or no, so they weren't actually necessarily something that would be revised. But with that said, we have an important activity today that we are going to move forward on. This first bill, S-140, would bring to us important members of Congress to amend the White Mountain Apache Tribe Water Rights Qualifications Act of 2010. And with respect to the members who are taking their time, I am going to move forth. I'm sure we'll have lots of times to discuss my frailties in the operation of this committee many, many times. Mrs. Slaughter, I promise you that I will continue to try and work with you and members of your committee, and I know on your side, and members on my side are wholly encouraged to do the same with you also. So thank you for joining us. Our first witness will be from the Natural Resources Committee, the gentleman from California who sans his lid, his cowboy hat today, so I almost didn't recognize him. The gentleman, Mr. Lamalfa, is recognized.
Well, thank you. Happy New Year, members of the committee. I'm pleased to be able to be in front of this committee today. Thank you for that, Albert. Mr. Chairman, today I'm here to testify in support of the rule for S-140 as reported by Natural Resources Committee with the addition of two sections consisting of the text of S-249 as reported by the House Natural Resources Committee and H.R. 986 as reported by the Education and Workforce Committee. The package of three bills, I call it a little mini package, would promote tribal self-governance and sovereignty over their lands, resources, and businesses belonging to Indian tribes. I'd like to first speak to S-249 as it was referred to my subcommittee on Indian, Insular, and Alaska Native Affairs, which I chair. S-249 would amend what is commonly known as the Indian Long-Term Leasing Act to authorize two Indian pueblos in New Mexico to lease their restricted fee lands up to 99 years, subject to approval of the Secretary of the Interior. Such leases may be for a variety of non-mineral development purposes, while current law generally authorizes Indian tribes, subject to the approval of the Secretary, to lease their trust and restricted lands. The terms of leases at this time may not exceed 25 years. So that's what the provision for 99 years would make more flexibility for these tribes. S-249 would authorize the pueblos of Santa Clara and Oki-O-Wingay to lease their restricted fee lands up to 99 years. Congress has amended the Indian Long-Term Leasing Act more than 40 times to adjust the terms and conditions of leases of Indian lands and to authorize leases of specific Indian lands by their Indian owners for a term of up to 99 years, subject, once again, to the approval of the Secretary. And just as a sidebar, this points out, I think, that more work needs to be done broadly to give tribes the autonomy to not have to ask permission every single time they want to do a piece of business like this. And so coming to Congress for a bill for each time, I think, violates some of that government-to-government relationship. So that'll be a different discussion for a different day. But the second bill, S-140, sponsored by Senator Jeff Flake of Arizona, is considered in the Subcommittee on Water Power, would amend current law to ensure the completion of a tribal water system in Arizona. 140 makes a technical amendment to the White Mountain Apache Tribe Water Rights Qualification Act of 2010 to clarify that authorization authority exists for any necessary cost overruns associated with the tribe's rural water system, provided it falls within the existing authorization level. The provision provides the White Mountain Apache Tribe and the Department of the Interior with certainty that there will be sufficient funds to complete their rural water system. So lastly, while the Natural Resources Committee does not have jurisdiction directly over the Tribal Labor Sovereignty Act, I wish to express my full support for it in 986 for the rule to allow for the consideration of this measure, promoting, once again, tribal self-governance by giving tribes parity with states and local governments for the purposes of the National Labor Relations Act. Tribal self-governance or sovereignty means that a tribe may make its own laws and be governed by them. Since President Nixon launched the era of Indian self-determination, tribes have shown that when they assume management control over their own affairs, they outperform the federal government. Thus, H.R. 986 will continue and enhance the policies of tribal self-determination that they've almost always enjoyed strong bicameral and bipartisan support for such measures. The addition of H.R. 96 is fully consistent with the broad goals of this three-bill package to promote the well-being, the opportunities for tribes and their economies, and the freedom in the recognition that we have in the government-government relations for tribes in this country. So thank you, Mr. Chairman.
Thank you. good friend, the gentleman from Virginia, is recognized for his opening statement.
Thank you, Mr. Chairman, ranking member, and other members of the committee. I'm here to testify on the Tribal Labor Sovereignty Act, H.R. 986, which is part of this bill. It's included as Section 3 of the Rules Committee print behind two non-controversial tribal and water bills. The Tribal Labor Sovereignty Act, which was marked up and reported out of the Education and Workforce Committee on a party line vote, which stripped thousands of employees of their rights and protections under the National Labor Relations Act at tribal enterprises located on tribal lands. I'm disappointed that the majority has elected to combine this extreme anti-worker measure with two non-controversial tribal water and land bills that were reported out of the Natural Resources Committee by unanimous consent, Sections 1 and 2 of the committee print, which incorporate S-140 and S-140 and S-249, dealing with the White Mountain Apache Tribe Water Rights Quantification Act and dealing with leases at the Santa Clara Pueblo, have nothing to do with workers' rights at tribal enterprises. They do not mitigate harms caused by Tribal Labor Sovereignty Act, and their combination serves no apparent policy purpose. These bills are non-controversial and would pass easily in the House on suspension if they were taken up separately, and if S-140 and S-249 have any meaningful connection with labor law, I'd look forward to learning what it is. So in reference to Section 3 of this bill, the Tribal Labor Sovereignty Act, we address two solemn and deeply rooted principles. First, the right of Indian tribes that they possess in matters of local self-governance, and two, the rights of workers to organize unions, bargain collectively, and engage in concerted activities for mutual aid and protection. Rather than attempting to balance these two important principles, H.R. 986 chooses sovereignty for some over the longstanding rights of others. I'd note that approximately 75% of the workers employed at tribal casinos are not members of the tribe running the casino, but this bill would strip them of labor rights that hundreds of thousands of workers enjoy. In doing so, the legislation would abandon the carefully drawn balance between tribal sovereignty and workers' rights that was adopted in a 2004 decision issued by a Republican-led NLRB. That decision, known as the San Manuel Indian Bingo and Casino, asserts that the jurisdiction of the National Relations Act only applies if it does not impact the exclusive rights of self-governance in purely intramural matters or abrogate rights guaranteed by Indian treaties. This decision also takes into account and accommodates the unique status of Indians in our society and legal culture. Consistent with these principles, and the NLRB found that the 1830 Treaty of Dancing Rabbit Creek foreclosed the application of the NLRA to the Chickasaw Nation's WinStar World Casino in 2015. I know this principle is important to tribes and members from Oklahoma. This particular decision shows that NLRB is fairly balancing the tribal and workers' interests. I will note that that decision has also been upheld in every appeals court where it's been challenged because it is bedrocked on the legal principles governing federal laws of general applicability with respect to Indian tribes that have been upheld by the majority of appeals courts over the last 30 years. As some contend, the tribal casinos should be considered part of a tribal self-governance and exempted from laws of general applicability. However, the courts have rejected that argument and found that tribal casinos are in fact commercial enterprises serving predominantly non-tribal clients and hiring predominantly non-tribal members to operate them. The courts have ruled that the tribes must comply with the labor and employment laws, such as the Fair Labor Standards Act, the Occupational Safety and Health Act, the Employment, Retirement, and Income Security Act, ERISA. Courts have also found that federal criminal statutes of general applicability apply to Indians in Indian country. Yet this bill singles out the National Labor Relations Act on the grounds that tribes should be given parity with state and local governments, which are also exempted from the NLRA. Relying on parity argument is completely inappropriate. State and local governments, for example, are covered under Title VII of the Civil Rights Act, where tribes are expressly exempt. For employees of tribal enterprises, unions offer the sole protection under federal law against discrimination, including sexual harassment, because they can negotiate a collectively bargained agreement that enforces employees' rights to be free for such contracts. And Democrats and Republicans have both insisted that in trade deals, trading partners abide by and enforce basic labor rights. And Congress has repeatedly ratified these obligations in trade agreements. Tomorrow, however, the House will vote on a bill that just does the opposite when it comes to freedom of association and the right to collective bargain at tribal enterprises. Mr. Chairman, I'd like to submit for the record an advisory opinion from the International Labor Organization from the last time the House considered the Tribal Labor Sovereignty Act as H.R. 511. The opinion noted that the bill would leave the United States with labor protections that fall below the internationally recognized labor standards. A fair question, then, is whether this legislation would place the United States government in breach of any of its trade agreements that were signed into law. This legislation would cause a cascade of harms. Existing contracts, labor contracts, may cease to be enforceable. When the labor contract expires, a tribe could unilaterally terminate the existing established bargaining relationship without any legal consequences. A small minority of tribes have adopted enforceable tribal labor ordinances that protect workers' rights to organize and collectively bargain. However, many other tribes do not have such tribal labor ordinances or ordinances that are ineffective or explicitly prohibit union activities. For example, some tribes have adopted policies that make it a fireable offense to solicit other workers, and one tribe in Montana has enacted a tribal labor ordinance that specifically prohibits unions outright. Everyone is open to responsible compromises that can protect both workers' rights and tribal sovereignty, but that's not what's before us today. It's an all-or-nothing approach. It's too sweeping. There is no principled basis for stripping hundreds of thousands of workers of their right to work together, join a union, negotiate for better wages, simply because they happen to work for a commercial enterprise on tribal lands. I'd be pleased to answer any questions that you have.
Thank you. Before we go on, without objection, the letter the gentleman referenced will be added to the record.
Thank you.
For that, we'll go next to my good friend from Indiana for his opening statement.
I thank the gentleman. I appreciate his leadership on this issue. I thank the members of the committee for being here. My apologies for having my back to some members of the committee. It appears to be the logistics of the room and the popularity of this three-part bill, which I appreciate the gentleman for bringing. So Happy New Year to y'all. Mr. Chairman, others before me have worked on this legislation, and I'm specifically addressing Section 3 of the bill, which mirrors provisions of the Bipartisan Tribal Labor Sovereignty Act of 2017 legislation I reintroduced last February. So speaking on about Section 3, others before me, I'd say, have worked on this legislation for nearly a decade, if not more, and have made great strides with perfecting the language we see now in this bill. Last Congress, I happened to take over management of the bill, but combined with the leaders in this room and on the floor of the House, first of all, foremost with Tom Cole from Oklahoma, we were able to pass this bill off the floor after it got out of this committee. And now with a positive vote again out of this room today, we are destined to repeat the feat for a second Congress in a row, if you'd allow it. And again, that's after 10 years of discussing the policies of this bill and finding that it is right and in due course to make this change to the National Labor Relations Act now. Now, what has happened, just to correct some of the information perhaps or clarify what's been said already, in 2004, the NLRB began to change its longstanding practice and adapted subjective tests to determine when right? These are unelected lawyers, unelected bureaucrats, when it wanted to assert the jurisdiction in matters involving Native American tribes. And why we should act is this. Tribal business leaders have been asking Congress to respect the sovereign rights and end the NLRB's inconsistent and misguided decision when it comes to labor decisions dealing with tribal businesses. Over 150 Native American organizations, as well as the U.S. Chamber of Commerce, have urged Congress to pass the Tribal Labor Sovereignty Act of 2017. Now, quite simply, it's a couple-page-long bill. What it does is protect the sovereignty of tribal governments and businesses and ends the NLRB's overreach into tribal labor affairs. It does this specifically by amending the National Labor Relations Act to clarify that the law does not apply to any enterprise or institution owned and operated by an Indian tribe and located on tribal land. This is important because what it's asking for is parity, simple parity with other sovereign governments, like every state and local government that is in every one of our districts. Now, the gentleman, my friend from Virginia, indicated that thousands of workers' rights would be stripped, and that's just not true. The NLRA does not apply to any state or local government, where thousands, perhaps millions, of our fellow citizens are employed. And so if the NLRA doesn't apply to any other state or local government, why are we so pejorative as to say that it should apply to the governments that are supposed to be sovereign, like those of Indian tribes, where we have treaties that specifically dictate their sovereignty and other rights and responsibilities? And that's simply what Section 3 of the bill before you aims to clarify and aims to problem it aims to solve. It prevents the NLRB from wrongly exerting jurisdiction over Native American businesses operating on tribal lands by restoring this well-established legal standard. It protects the sovereignty of Native American tribes, reaffirming that they are afforded the same rights and same protections enjoyed by state and local governments. It ensures tribes have control over their labor relations, which they ought to be able to have, and can determine what is best for their workplaces. It eliminates the legal confusion and uncertainty that is hindering the ability of tribal governments to serve their citizens. I want to also reiterate what this bill does not do, hopefully putting at ease any confusion or tension that a member here might have based on some inaccurate information they may have received. The Tribal Labor and Sovereignty Act of 2017 is focused on protecting sovereignty. Critics falsely claim that the bill has sinister intentions. For example, that it may prohibit unions. Now, this is simply untrue. The bill allows sovereign tribal governments to engage in labor relations as the tribal government sees fit. Not how we see fit, not how unelected bureaucrats at the Department of Labor see fit, but how that government sees fit, and those tribes should have control over their own labor relations and determine what is best for their workplaces, free from Washington. Again, just like every state and local government in every one of our jurisdictions has. Tribes have formed their own labor standards. In fact, the Navajo Nation protects labor rights specifically, and so do many other tribes. A tribal state gaming compact in California, for another example, protects these as well. So if the tribe engages in some other kind of state pact, well, that's between the state and the tribe, not our forum. The accusation is that deprives constitutional rights of workers, and this is just patently false. The bill is only about the NLRB's jurisdiction on tribal issues, having nothing to do with constitutional rights. And it doesn't create a workaround for the NLRB for any business or anything else. The bill only applies to tribal governments and businesses on tribal lands. And by the way, state and local governments do engage in business. I happen to take my two sons to a water park in my district this year and was amazed at the business the town was operating. And I did the same thing the year before. That's just one example of sometimes how businesses are run by state or local governments. Nothing is different here with our friends from tribal communities, and they should be free to run those businesses as they see fit, just like, Mr. Chairman, our state and local governments do. That's the purpose of this bill, simple parity. Let's treat our friends in the Native American tribes just as we treat our friends at state and local government. I yield.
Thank you, gentlemen. The gentlelady from Wisconsin, my very good friend, is now recognized for whatever opening comments she cares to make.
Thank you so much, Mr. Chairman, ranking member, and members of the committee. I am really pleased to be here with this eloquent panel, and I want you to forgive me in advance for repeating things that may have already been said. But I'm here to express my support for the Tribal Sovereignty Labor Act, Section 3 of this package of bills, and I'm asking for an open rule for consideration in the House. I am absolutely delighted to be here with members of the majority party and to hear about their strident support for sovereignty. And I will be continuing to remind them of this day and this moment. From this day forward, I will be reminding you of this. I do think that our dear friend from California did mention Richard Nixon's efforts to not engage the tribes as independent sovereign nations. And since then, I'm very, very proud, since I have been here, to see this body really struggle with sovereignty, to take it on. I was in this room when we discussed the Violence Against Women Act and the need for tribes to have sovereignty. And to see this body really try to deal with these issues I do think is very complicated. As my good friend from Virginia mentioned earlier today in caucus, that this issue we're dealing with is we're dealing with issues of friends. Both labor and tribes are friends. So this is why there is some difficulty. I think this bill is really needed because when Congress originally passed the National Labor Relations Act in 1935, Congress, of course, exempted federal, state, and local governments from the definition of employer under that law. The law was silent on tribes, but the NLRB, for 60 years, although it was silent on it, it held that it didn't apply on tribal lands or tribal governments. They were recognizing that tribes were eligible for that exemption granted to other governments. And of course, in 2004, they abruptly reversed their precedent and started adopting a new, quote, jurisdictional standard, unquote. And this, of course, raised alarms among our friend and tribal lands, but it also raised alarms from the Interior Department, the department that is that we authorized to deal with these sovereign nations. I mean, if we truly believe that tribes are sovereign, then they should be treated the same as state and local units of government, no more, no less. And so now, with this legislation, Congress is stepping in to restore this prior long-standing understanding of how this important law applies to tribes. This is a very, very narrow legislative fix, as the gentleman from Indiana has pointed out, and it simply adds tribal governments to the list of other governments excluded from the definition of employer in the National Labor Relations Act on tribal lands, not the Indian business in the middle of Harlem. I also want to make it very, very clear to my friends and colleagues who are Democrats. I'm a strong supporter of labor. I put my labor record up against anybody's. I guess it's going to fall a little bit after Wednesday. However, as a longtime labor advocate, I support this bill because I believe in sovereignty. Wish we could be free, but anyway, that's a different moment. In my own district, I have seen tribes afford their workers good pay, good health care benefits, and I'll tell you, the employees at our tribal casino, many of them are African Americans who have health care, unlike many of the businesses that are not tribal businesses that don't offer that benefit. I believe that tribes, given the sovereign choice, will do what is right when it comes to collective bargain with unions and treating unions employees more fairly. I did hear Mr. Scott refer to states that haven't done that, and I would encourage those workers to continue to prevail upon their government to treat them well. As many of I'm from Wisconsin, a place where all kind of workers' rights have been stricken down by actions of the state. And so I think that that we need to support the ability of people to organize, whether they're state employees or whether they're tribal employees. But that is the prerogative of these sovereign peoples. Promoting the sovereignty and promoting the economic, political, and social self-determination for the Native American community has got to remain a congressional priority. I know it's one of my top priorities. I just want to end with a little story. Long before I was ever elected to anything, we had a referendum in my state to allow a lottery in the state of Wisconsin. And I was so terrified of gaming that I ran out right in the middle, the week that my mother died, which is the worst week in my life, to vote against the lottery. That following year, I was elected to the Wisconsin State Legislature. And lo and behold, what they learned is that if we allowed a state lottery, we're going to have to allow Indians to game in our state. And there was so much opposition to that. And I found myself in the same quandary I find myself here today. I hated gambling, but guess what? These people were sovereign. This is what they get to do. And so I stand on that principle. And again, I will be back here soon to speak on a rule to bring the HASDA reauthorization legislation to the floor for consideration, something that I've been working on a bipartisan basis for a number of years with very capable partners such as the vice chair of this committee. And that legislation will enable this body to fulfill yet another key piece of its responsibility to our tribal brothers and sisters, and I yield back.
I want to thank the gentlelady for her testimony. Let me begin by first thanking all four of you. Those were excellent opening statements. You all clearly know the issue extremely well. I do think, to my good friend from Virginia, we got you outnumbered today, at least. But no more able advocate for any cause than my good friend. I do want to take issue with one part, not issue, but add a broader explanation. You mentioned the Chickasaw case in your opening statement. In full disclosure, I am Chickasaw, so I know that case very well. And in that case, we took the NLRB to court to get them to change their mind, and we won the case in the federal court in Oklahoma City that they had exceeded. I suspect they then made a decision. We don't want to keep going. Read the opinion. It's a brilliant 34-page opinion. We don't want to keep going on with this, and they just pulled back from that because I think they would have lost later judgments. And we were quite prepared to go all the way to the Supreme Court. So that doesn't show, that may show discretion and good judgment, but had we not had the resources to take them to court, we would have been in a very different situation. So this was not the generosity of the NLRB. We beat them, and they thought they would continue to lose. In terms of, I think my friend said, and I want to say for the record, I know this does create some strange difficulties and dilemmas between people who are normally allies, but it's not really a partisan question. To me, the same thing was true when, and my friend from Wisconsin was so terrific on this, on the Violence Against Women Act. That wasn't really a partisan deal. That was about sovereignty, as she said. And I'm glad you're here to remind people of that. And I know you will remind some of my colleagues. You're very helpful in that regard. But in this case, and I think my friend from Indiana said it very well, and I'm going to ask him a couple of very direct questions just to make it crystal clear for the record. This was not a case where an administration or the Congress asked the bureaucracy to extend its authority. This is a place where, as my friend from Wisconsin pointed out, for 60 years, they had followed the obvious course: we don't interfere with governments. And in this case, with just these kinds of governments, it'd be very different if the NLRB said, I think we need to regulate, I think Virginia, the liquor stores are state-run, so those are government employees, I assume. I may be wrong about that. We're going to move in and regulate that. or golf courses someplace else. Or, I mean, we have many instances, my friend pointed out, where state and local government runs what would look like a normal business. And we don't have any jurisdiction, the NLRB doesn't have any jurisdiction in those cases. It shouldn't have them where tribes are concerned either. So let me ask you this, Mr. Rikita. To your knowledge, did the administration, which would have been the Bush administration, ask the NLRB to take this course?
Thank you, Mr. Chairman. In response to that question, I'd say no. No, not at
and
all. For 70 years, it was clear that governments didn't have to be subject to the NLRA.
Now, was there any congressional action, legislation giving them additional authority to apply their jurisdiction to Indian tribe?
No, sir, not that I recall or know.
I can assure you there was not. And so in this case, you really do have the classic case of mission creep by a bureaucracy. It's decided it wants to do something. Is there any other place, any government that we applied? What the NLRB basically did was say, okay, you're a government, you have employees, but some of those are governmental employees. So we don't try to assert jurisdiction over police, tribal fire, healthcare, those sorts of things. But some are commercial, and we're going to define that as a place where we have authority. Have we done that? Has the NLRB done that to any other government?
Mr. Chairman, members of the committee, no, not in my experience, not that I recall. And I would also add that if that were to be the case, every member here would have a line out the door of their local mayors, town councilmen, others who would be roaring, let's say, about the inequity of such a move by an unelected bureaucracy. It should be no different for our Indian friends and neighbors.
Yeah, I just want to conclude by, number one, we've had these fights over sovereignty, and I want to commend President Obama was terrific in these fights. Probably, you know, he and Richard Nixon, oddly enough, the two best presidents for Native Americans in modern history. I don't know that either one of them would like to be paired that way, but the reality is it's true, and it suggests these really aren't Republican or Democrat, normal partisan issues. And you'll see some odd alliances, I'm sure, on the floor. There'll certainly be some Republicans that support my friend Mr. Scott's position on this, and there'll be some Democrats that support my friend Mr. Rikita's position on this. But this is really about applying, as my friend from Indiana said, the exact same standards to governmental units. And if we want to make them all subject to the NLRB, that would be a fair position to take. But to single out Indian tribes who for 60 years were not under the jurisdiction of this agency, let the agency itself, without congressional authorization or administrative direction, extend its authority here, I just think is an egregious overreach of bureaucratic power. And I want to commend my friend from Indiana. He's right. This has been a better than a decade-long struggle, but you're the first one to get it passed. And our friends on the other side of the rotunda, you know, have passed it out of the Indian Affairs Committee. And I suspect we'll have the votes because it'll take 60 over there to actually approve this. So again, I want to commend the panel, but I particularly, you know, want to commend my friend from Indiana for his many years of work, my friend from Wisconsin, because she's always on the right side on tribal sovereignty issues, and she's been extraordinarily consistent. My friend from California, who allowed this legislation to move to his committee, and to be fair, my friend from Virginia is correct. The other two items are pretty non-controversial. This one is, but my understanding, this is the easiest way for the Senate to actually deal with this legislation, which has demonstrated it wants to by moving it through committee. And my friend from Virginia is always an able advocate. I enjoy it much more when I'm on his side, and occasionally that does happen. But I'm heartened by my friend from Wisconsin being here. It sort of suggests to me that my friend from Indiana has worked really hard across the aisles together. So with that, I just want to thank you guys, and just excellent testimony. I have no further questions. My friend from Georgia. No questions, Chairman. Gentlelady. Friend from Texas. Any question? My friend from Colorado. Oh, I'm sorry.
I appreciate the presentations of our witnesses, and I just ask unanimous consent to include 3 letters from labor unions, the International Brotherhood of Teamsters, in opposition to this measure, the AFL-CIO in opposition, and Unite Here. Additionally, in support of the measure, I would like to introduce a letter from the Seminole Tribe of Florida that I'm privileged to represent, and they very strongly support the measure that's offered. That's all I have.
Gentleman from Colorado?
Yeah, I just wanted to add, we had hearings last session of Congress on this bill. I was the ranking member of the Labor Subcommittee at the time. And, I think one thing that stands out is that workers have rights in this country. And it doesn't matter what state or tribal nation they live in. People who live in tribal nations are American citizens too. And the right to organize is fundamentally a right that workers have. And people don't lose that right simply because the employer happens to be a business that's owned by a tribal nation. One of our witness that was against the bill, and I understand it's nearly identical to the bill that was last session, so this has been brought before this House before. We had a Native American worker who himself, as a member of was a member of a tribal nation, but of course still felt very passionately that he shouldn't have to sacrifice his rights as an American simply because the employer is owned by a tribal nation. So we have inalienable rights, and I think the right to organize and form a union and collectively bargain is one of those. And I don't think people give that up just because of the type of organization, in this case a sovereign Indian nation, that happens to be the owner of the business in question. And I yield back.
Thank you, gentlemen. Any more questions from the Republican side? With that, thank you very much for your testimony and your excuse. Our next panel is called forward. Okay. We'll actually take a pause until our real chairman can come back and assert control and authority here appropriately. Since we're voting, we're going to recess.
No, we're not recessing it. We'll affirm it. We're checking to see if.
If we can, we're going to go ahead and call Mr. Schiff and Mr. Nadler forward so you can get your opening statements in the record, if that's all right. And we're searching for Chairman Nunes as well. Yeah, we certainly won't be voting, so if you want to go down and vote and come back, that's perfectly appropriate. I'm sorry?
Yes, they are.
But if we can, we'll get as much as we can get done so we can come back and question you. So with that, if I can, I'll begin with my good friend from the state of California to make whatever opening remarks he cares to make.
Thank you. Thank my colleagues. The bill before the committee is an effort to bridge a number of differences within both House and Senate and reauthorize the 702 program. I think it's a responsible compromise. I'm sure any of us that were writing it would write it in a slightly different way, but I think it meets both the national security objectives of this very important program and at the same time addresses a number of the privacy concerns that have been raised. This is the second major program that we have worked to reform post-Snowden. The first was the telephone metadata program. We reached a very bipartisan compromise in that reauthorization. The 702 program is, in most respects, far more significant than the telephone metadata program in the sense that it is responsible for alerting us to many plots as well as our allies. Our allies are, in many respects, an even greater beneficiary of 702 collection in the sense that we're able to inform them of plots against them. The most significant issue that's come up in the context of 702 is 702 is a program that is focused on foreigners on foreign soil. Thank you. When we capture communication of a foreigner on foreign soil, there are times when that foreigner may be talking about an American or maybe talking to an American, even though that was not the intent of the surveillance. That incidental collection goes into the database along with the overwhelming content that is purely foreign-based content. And so the most significant privacy question that's come up in this context is, under what circumstances should you be able to query that database using a U.S. person identifier? Now, from my point of view, and I think the courts are in accord on this, it is lawful, it is constitutional for law enforcement and the intelligence community to query that database using a U.S. person identifier because that data is lawfully in U.S. government hands. But we often do things here that go beyond the requirements of current law or requirements of the Constitution. And here, this bill goes beyond to put in place privacy protections. Likewise, the amendment that my colleague, Mr. Nadler, offers goes even beyond that to put in place privacy protections. The privacy protection that the bill, the base bill before you would put in place provides that when you do a U.S. person query of the database in a non-national security case and you have an open investigation, you're required to get a warrant first. The goal of that is to prohibit the law enforcement agencies from using this database as basically a big pond for a fishing expedition. Let's say that I'm a prosecutor prosecuting someone for tax fraud and I want to know, well, is there any evidence of tax fraud in this database? Let's query the database. This bill would say, there's an open investigation into tax fraud. I need a warrant to do that. Now, it does provide that if you don't have an open investigation, if it's pre-investigation, you can do a query of the database. And that is a big exclusion. But it also has a use restriction on information that is gathered. So if you do a query of the database in a tax case before an investigation is opened and you find evidence of tax fraud, you're barred from using it if you haven't gone to get a warrant. And so those are the restrictions that it would put on queries. There are some other significant provisions in the bill, including about collection, which I'm happy to go into with your interest. But again, this is, I think, a responsible compromise between those who would say we ought to have a clean reauthorization and those that say we shouldn't be doing queries of U.S. persons under any circumstances. And so I submit that for your consideration.
Thank the gentleman for his testimony, and just if you have anything in writing that you'd like to leave for the stenographer when we're done, that would be very welcome indeed. Now I recognize my good friend, the ranking member in Judiciary from New York, Mr. Nadler.
Well, thank you, Mr. Chairman. No one questions the, I shouldn't say no one here questions the use of Section 702 to gather information about foreign, non-U.S. persons on foreign soil. The entire question comes with respect to the use of so-called incidental information, that is, information collected about American persons or in communication with American persons in the United States. Let us be clear. Although supporters of S-139 have billed this legislation as a reform bill, this legislation does not include meaningful reform. A meaningful reform package would have three components. First, it would address the fact that Section 702 sweeps in massive amounts of information about U.S. persons, and that the FBI is free to repurpose that information for wholly unrelated, purely domestic criminal investigations without a warrant. Second, it would address so-called about collection in a manner that is to say when you hear two foreigners speaking about an American. It would address so-called about collection in a manner that allows Congress to speak in a meaningful way before the government starts it up again. Third, it would include input from all stakeholders. S-139, the bill before us today, fails all three of those tests. First, this warrant requirement, I put that in quotes, applies only to fully predicated official investigations and not to the hundreds of thousands of searches the FBI runs every day to track down a lead or check out a tip. The FBI has admitted to my office that they will almost never be forced to use this provision in order to access our communications. This measure is also riddled with loopholes. It does not apply to any search, quote, related to national security, unquote. The bill fails to define this term, so the government will have every incentive to take advantage of this ambiguity and read it as broadly as possible. Similarly, the bill's exception for information that, quote, could assist in mitigating a threat, unquote, threatens to swallow the entire rule. The Fourth Amendment permits a carefully tailored emergency exception to protect the public. But any search might assist in mitigating a threat, and this language will permit a wide range of unconstitutional searches. Second, this legislation fails to address about collection in any meaningful way. In fact, by codifying this practice, S-139 makes the underlying statute worse, not better. The 30-day notice proposed in this bill does not address the government's terrible track record on about collection, nor is 30 days a meaningful amount of time for Congress to stop them if they get it wrong again. The Foreign Intelligence Surveillance Court has twice taken a hard look at about collection. Both times the court accused the government of, quote, an institutional lack of candor, close quote, that is lying, with respect to the large amount of purely domestic communication being dragged in by Section 702. And both times the court found the program to be inconsistent with the Fourth Amendment. Last year, when the court threatened to shut down Section 702 altogether, the NSA volunteered to temporarily suspend that type of collection. Until Congress has been satisfied that the government has the technology to conduct this type of collection responsibly, it should not be reauthorized. Finally, all stakeholders have not been at the table to reach consensus on the legislation. The Judiciary Committee has primary jurisdiction over the Foreign Intelligence Surveillance Act, and especially over the FBI and the Justice Department. We take that responsibility on a bipartisan basis seriously, and for almost a year, we worked to draft legislation that preserves the strength of Section 702 while moving the authority more in line with our values. That work included dozens of meetings with the Intelligence Committee and the intelligence community. The bill we produced, H.R. 3989, the USA Liberty Act, passed the committee with overwhelming bipartisan support, 27-6, and directly addresses the issues of U.S. person information, about collection, and building consensus around these reforms. S-139, the bill before us, tells a very different story. The key reforms, such as they are, appear to have been written by the intelligence agencies for the intelligence agencies. It was drafted without any input from the Judiciary Committee, Democrats or Republicans. It has twice been retooled so that it can be sold as a reform bill. I think our members know better. At its core, Mr. Chairman, Section 702 ought to be about compromise. The authority allows for the collection of a massive amount of information. During that collection, particularly during the upstream collection of communications from the backbone of the Internet, our intelligence agencies are not able to filter out solely domestic U.S. communications. We allow the government to collect this information, along with the foreign communications that are the true target of Section 702, because at present there is no other technological choice. This is a compromise. We allow over-collection so long as the government carefully minimizes this incidental collection and uses the information properly on the back end. But the government has not lived up to its end of the bargain. It treats all incidental collection as lawful collection and uses it as it pleases. And such massive collection, although presently unavoidable, is not merely incidental in the same way a police officer conducting a targeted search happens upon the evidence of another crime in plain view. When Congress designed Section 702, it did so to solve a foreign intelligence problem, not to give our law enforcement agencies access to such a treasure trove of information that would require a warrant to access in any other circumstance. So let's make this simple. If the FBI does not have probable cause to believe that someone is committing a crime or that an act of terrorism is being planned, it should not be able to use the Section 702 database to read the private communications of U.S. persons. Most members agree with that principle and would overwhelmingly support an amendment of that nature if given the opportunity. Two amendments before you now, the Ted Poe-Zoe Lofgren amendment and the Amash amendment, would give us that opportunity. The Poe-Lofgren amendment addresses these problems in a targeted fashion, imposing a real warrant requirement and terminating about collection until Congress says otherwise. The Amash amendment is a more substantive package of reforms, but also far preferable to the underlying bill. I will let the authors of these amendments speak about them more extensively. I urge this committee to make both proposals in order as amendments to the underlying bill. I cannot support S-139 without amendment. I will urge all my colleagues to oppose it as well, unless one of these amendments, the Poe-Lofgren amendment or the Amash amendment, is adopted. We can reauthorize Section 702 responsibly and safely in the coming days. But this bill, unless amended by one of these two amendments that you hopefully will make in order, is not the right path forward. I thank the chairman, and I yield back.
Mr. Nadler, thank you very much. I'd like to advise members, they know that we're on a vote right now. I have voted. I encourage members to vote, but what we're planning on doing is hearing testimony that would be from the chairman of the committee and then would go subject to recess to the call of the chair. But I want to inform all members we're going to allow Mr. Nunes to make the necessary time that he sees and that he has voted. Well, that was what I was told. If you'll give me further update right now, excuse me. Oh, we're now far enough along, and I apologize for that. Mr. Nunes, I know that you were brought up here with the understanding that we would allow you to give testimony right now. In fact, the time has continued, and so I'm going to ask that you stick around. We've got how many votes on the floor right now? 3 votes on the floor. I apologize for the inconvenience to each of the members. We're going to now remove ourselves to the floor, subject to the call of the chair at the end of that, immediately after that, and we will then come back to testimony that would be on the 702. And so, subject to the call of the chair, we're now in recess. Rules Committee will come to order, and thank you very much. We've now finished this vote series. It's now 4:39 in the afternoon. We are continuing the Rules Committee meeting Tuesday, January 9th, continuing testimony on S-139, Rapid DNA Act of 2017, Fisa Amendment, Reauthorization Act of 2017. We have completed testimony on behalf of two of the members, the gentleman, Mr. Schiff, the gentleman, Mr. Nadler, who have provided testimony to the Rules Committee. We'll now move to the young chairman of the Intelligence Committee, the gentleman from California, Mr. Nunes. Mr. Chairman, as you may know, anything you brought to the hearing today without objection will be entered the record, and we appreciate you leaving behind any of that so that our awesome stenographer is able to properly connect the dots and finish the testimony as it existed today. We want to thank you for taking time. We know your time is busy. Mr. Nadler and Mr. Schiff, we want to thank you both for taking time to come back before the committee. After hearing your expressed ideas, I think it's important that the committee have a chance to offer their rebuttal to you. Thank you very much. The gentleman, the young chairman is now recognized.
Thank you, Mr. Chairman. I will keep it very short. We've been before you before, and I think everybody is quite familiar with the importance of Section 702, the FISA Act. It's a critical intelligence tool, as you all know. The language before you today is a product of extensive negotiations over the course of, I would not only say past several months, but several years within the House and the Senate. Currently, the House Intelligence Committee, the House Judiciary Committee, the Senate Intelligence Committee have all passed reauthorization bills out of their respective committees. This bill, I think, reflects a compromise between all of those three bills and has the support not only of a majority of Republicans and Democrats, but also with the administration. So a bill written like this can pass the House of Representatives, I think has a very, very good chance of passing the Senate and would be signed into law. And I think that's really what we're looking at here is that's what a compromise is, and that's what we've done. And with that, Mr. Chairman, I will yield back.
Mr. Chairman, thank you very much, not only for your hard work on this, but I'd also like to thank the other gentlemen and others who are here to give testimony for their important work on this issue of 702. This committee is engaged in this issue as many other members of Congress, including Judiciary, the Intelligence, and other committees, Armed Services committees are very interested in this. Mr. Nadler, you referred to what I wrote down as part of a statement that you gave about collection of massive data.
Massive amounts of data.
Collection of massive amounts of data with the record would show. I just wrote down what I heard you say, and thank you very much. And that you have a concern about that collection of massive amount of data if it is derived or brought forth without vetting to the direction that you would like of obtaining a warrant.
No. I don't have a problem with the collection of that data. The collection of that data is inevitable as long as you're doing the surveillance of foreigners. The data is going to be collected. I have a problem with the use of that data in domestic criminal investigations without a proper warrant.
The compromise appears to me to be one where the information that would be gathered on an American citizen, where it fell outside of that necessary contact of 702, and that the compromise is then a warrant will be required for extraneous, what I would call extraneous information. Is that?
No, I think you're confusing two parts of the bill.
No, I'm not trying to confuse anybody.
I didn't say you're trying to confuse it.
About how you would.
No. I'm not sure whether you're talking about the about collection or about the warrant requirement.
About the warrant.
Okay.
Which is the compromise.
Well, all right. The judiciary, well, the two amendments before you say that you cannot use information gathered about an American without a warrant, period. The Judiciary Committee bill says that you can't, that when you find out that that you can access the database when you find out that this piece of information was gathered from when you find out that there is Section 702 information available, you cannot look at that without a warrant. Okay. This bill says that you need a warrant when with certain, subject to certain exceptions, which I think swallow the rule, but you only need it for fully predicated official investigations, and only, and you cannot use that information if it's only in court. Now, the Department of Justice guidelines outline the steps the FBI must take from the first tip to a fully predicated criminal investigation. It starts with any tip or lead. The FBI gets a tip or a lead. The guidelines say the first thing the FBI should do is search the database, which includes Section 702 information. Thousands of these searches occur every day. Under either amendment or under the Judiciary Bill, that would not be permitted. The guidelines then say, the FBI guidelines then say, you build to an assessment, still not going for an indictment, but developing the case. And under the bill, still unrestricted access to 702 without a warrant. Then, only when the within the case is fully developed, does the FBI open an official investigation, and only then does the rule in this bill apply that says you need a warrant. So in probably 99% of the cases, you can use this information about an American citizen gathered, or this information that you heard an American citizen on foreign surveillance. You can use this information in a domestic criminal inquiry 9/10 of the way down the road, and only in those few cases where you decide you've gone through the tip phase, through the assessment phase, and you're now at the fully predication phase, only then does the warrant requirement kick in. But for most cases, you don't get to that point, and you've used this information without the warrant. And that's what the two amendments and the Judiciary Bill would say. You can't do that. You need a warrant in the case of the two amendments, period, if it's going to, for any information in a domestic criminal case. In the Judiciary Bill, you need a warrant once you've decided to interrogate the database, the 702 information that you know is in the database. This bill says you can interrogate that to your heart's content until the final stage, in effect, of the investigation.
Mr. Chairman, about how long does a normal or average or even an expedited review take before, in this case, what would be the FBI to develop what the gentleman just referred to in an investigation?
Well, normally this is, I don't know of any examples actually where American citizens have been, maybe they're out there, where American citizens have been prosecuted based on this information brought in some way that wasn't with a warrant, where there wasn't already an investigation that had been started. I know of no examples of that. I would only say that, if we forget Fisa, forget 702, and if you look at, any wiretap of an American citizen that's legally obtained in this country, where that American citizen is picked up talking to another American citizen, where they're talking about what could possibly be a different crime, even at that time, even at the lowest level of surveillance. I'm not talking about FISA, I'm talking about domestic surveillance, warranted surveillance. Those Americans that are picked up on a different crime could actually be investigated using that wiretap with that surveillance. What we're talking about here is bad guys, overseas, foreigners, where we're picking up intelligence, and we're actually adding a step beyond that, where if any of that extraneous information, as you said, was to be used in in any type of investigation for another crime or another matter, they would have to go get a warrant. So I think this is a compromise, and I think look, I have my own concerns about abuses at DOJ and FBI, but with the 702 program specifically, I don't have any concerns at this time. And if there ever were any concerns, you can bet that I would bring it to my colleagues.
Is the development over time one of those issues of the time requirement?
Well, the time requirement is what, the timing requirement is one of the reasons why the FBI and the other intelligence agencies say that they cannot use what's currently drafted in the bill, which is why we came up with a different version working with our colleagues, a compromise version.
One last question. That warrant that would be obtained, is that through federal district court, or is that back through the FISA court based upon some criteria?
I believe it goes to the FISA court.
Come back through the FISA court where there would be an understanding that it originally started here, and based upon that, we're looking at that. And I think that is a wise use of resources and also people who are in that business day to day. Thank you very much. Chairman Cole.
Mr. Chairman, I have no questions.
Gentleman has no questions. Yields back to the gentleman from Massachusetts.
Well, I want to thank you all for being here. I don't really have any questions, but, you know, as the bill is currently drafted, I would oppose it, and I'd like to ask unanimous consent to insert into the record
Without objection.
letters from the Open Technology Institute, the Center for American Progress Fund, the Brennan Center for Justice, and the ACLU, all in opposition to this bill. And I would just say that I hope that that all the amendments that are being brought before this committee, given the sensitivity of this subject, would be made in order, because I do think that on this issue of privacy and civil liberties, I think everybody in this House is deeply concerned, and people have strong opinions, and I hope that on this bill there'll be wide latitude to make sure it's not just one, but as many amendments as are being offered here that are germane. I hope it will be made in order. With that, I yield back.
Gentleman yields back his time. Thank you very much. Gentleman from Louisville, Texas, Dr. Michael Burgess.
Thank you, Mr. Chairman.
Yes, sir.
Chairman Nunes, I've got a question, and it's one that the tech community has been concerned about it, and it's a little, I'm not even completely certain that I understand it completely, but let me do my best to set it up. There's an article in the New York Times from April of this year said the agency is no longer collecting Americans' emails and text exchanged with people overseas that simply mention identifying terms like email addresses for foreigners on whom the agency is spying, but are neither to or from those targets. When this information that it was being collected came to light, Senator Wyden expressed concern, and I'm going to quote from him, ending the practice. He says, "This change ends a practice that allowed Americans' communications to be collected without a warrant merely for mentioning a foreign target. For years, I've repeatedly raised concerns that this amounted to an end run around the Fourth Amendment. This transparency should be commended." Now, you mentioned in your opening remarks that there was substantial agreement between your committee and the Senate language on the total bill, the entire bill. Does it include language that you feel would be acceptable, Mr. Wyden, on the abouts?
Well, I've never spoke to Mr. Wyden on this, but on the abouts issue in that story, you know, like per normal, they're using selective leaks to write these stories. So I would be very careful about taking any news story and using it for anything at this point in time. However, we do have concerns with the abouts process. We handle that in this bill. If they were to restart it, they would have to come back and brief the committees, which would give us time to raise objections on that. And I can't imagine them.
I think that is my question, that
Yeah.
if it were restarted, there would be an appropriate amount of briefing and communication and transparency that was the case.
Oh, absolutely. I think it would have to be, I think you'd have to have sign off from both the House, Senate, or House and Senate Intelligence and Judiciary Committees before the IC Intelligence Community was to restart that program. I can almost guarantee that, Dr. Burgess, but
That
I
is
would
the
hope
question
would
that
be
was
the case.
posed to me by people in the tech community, so I appreciate your answer. Yes, sir.
In answer to your question, that is one type of about collection that the court found it was stopped because the court objected to it, said it was inconsistent with the Fourth Amendment. This bill would codify it, and that's why I said it would make the existing law worse. It would codify the about collection, subject to a 30-day notice. Congress would have 30 days to stop it. Now, imagine Congress having 30 days to act, and if Congress didn't act within that 30 days, it would go into effect, a reestablishment of this. And that's one of the objections to this bill. And Senator Wyden, and the Amash amendment, or the Amash amendment before you, is in fact Senator Wyden's bill. If Senator Wyden were satisfied by the provisions of this bill, he wouldn't be having that bill, and it wouldn't be, and that amendment wouldn't be before you.
Burgess, I could just add on this. There were a couple concerns that some of the tech community had about the about collection. Senator Wyden doesn't want the about collection, I think, to take place at all, and I can certainly understand that point of view. The intelligence community had been doing about collection. That is, you could collect not only on a particular identifier, but when people are talking about a particular identifier. The IC had to stop doing it because technologically the way they were doing it was also bringing in other information beyond what the FISA court had approved. So the issue is, if the intelligence community is able to make the technological changes to bring the collection under what the court authorized, should they be allowed to resume that collection? Under the base bill, if they are able to fix the technological problem, they have to go back to the FISA court and get the FISA court's approval to resume the program. Congress would then have time to, they wouldn't do it immediately. We'd have 30 days to essentially pass disapproval if we chose. There was another issue that the tech community had in the Senate bill on about, and that is that it thought that the Senate made a change to the definition of about collection that broadened it in a way the tech community was concerned about. That has been amended out of this bill, and I think we have a different definition that was more consistent and addresses the tech sector's concern about that particular provision.
Very well. I'm not unconvinced that we couldn't act with facility if it was required. So I appreciate all of the observations on this. And thank you for your testimony and being here and your work on this.
Gentleman yields back his time. At this time, I'd like to enter to the record without objection Statement of Administrative Policy, House Amendment to S-139, the FISA Amendment, the Reauthorization of Act of 2017. And I will offer one bit, the first paragraph, last paragraph. The administration supports passage of House Amendment to S-139, the FISA Amendments Reauthorization Act 2017. The last paragraph, if the House Amendment S-139 were presented to the President's current form, his advisors would recommend that he sign the bill into law. So without objection, I'll be entered the record. The gentleman from Colorado. Gentleman does not seek time. Thank you very much. The gentleman from Georgia, the gentleman is recognized.
Thank you, Mr. Chairman. And I'm not going to spend a lot of time here. I'm going to be on the floor tomorrow with this from the rules perspective as well. This is one I think, and I spoke of, I know, with our conference this morning, is the issue as we move forward, I think, has been, is this everything I'd like to see? No. I mean, I'm from the Judiciary Committee. I voted for the bill that came out of the Judiciary Committee, and you know, there's things that we can work on. With the Intelligence Committee, I've worked with very heavily, and from my background, also concerned about. I think the issue that we have here is a compromise bill. I think in its current form, as the chairman just laid out, the Statement of Administrative Policy is a good look here. I do want to take one exception. I think one of the things is that I have found in sort of a, not just this issue, but a more lighter note, you find something that inflames the passions of people that would get started again about like a bouts program coming back up. This place works sometimes too fast. And I think if this came back up, this would be something that would get this body moving very quickly. I think the Intelligence Chairman Nunes has talked about it. This is something that we've looked at. The concern here is finding that proper balance. And I think the issue is finding that those for looking at the criminal offenses that are non-domestic terrorism related is making sure that the privacy is protected and that the warrant requirement is there. That is something that we've talked, Ms. Nadler, we've talked about in our committee. I believe that we've gotten to that point to where this is, after talking to the Attorney General this past week and looking and basically bringing them along where they did not even want to go here, this provides us something that we can move forward with. I think in looking at this, it is also the concern, and I share the Chairman of Intelligence Committee's, Chairman Nunez's concern here. There are other issues that I am very concerned about that come out of our committee, Mr. Nadler, that is in our area and dealing with Fisa and dealing with these courts and dealing with the things that you and I have sat through these hearings on. I want to focus on getting this reauthorized, not letting this go dark, letting this be a part of, with the improvements that have been made. Remember, just a few years ago, this was approved, I'm not mistaken, by unanimous vote with no changes. It was just reauthorized in its current form. This is at least moving us toward changes. It's taken a while, and I know Mr. Marshall worked very hard on that. In fact, I even voted for, I think, one of yours first amendment because I wanted to see us push forward on this. I believe we have pushed forward, but at this point in time, I think this is where we need to be. This is the bill in its current form that needs to pass. I want to focus on the things that do move us forward, protects our American citizens, protects those public policy rights, and does those things that I know the chairman is committed to, and then we need to make sure that we're working on in the Judiciary Committee from the structural standpoint as well. So I appreciate the concerns. There's a lot of debate. It needs to be had on this bill. I'm glad that this is something that we need to work on, but at the same point in time, when you balance national security and the issues that we have with the privacy rights, which are getting protected, especially from things that we have seen from the FBI recently, and how this is being used, having that warrant issue now for the criminal investigations, not the national security and domestic. Those are terrorism, those are the kind of things that I think are appropriate in this. That's why I'm supporting this. Look forward to working with the floor on tomorrow with the rule. And Mr. Chairman, with that, I yield back.
Thank you, gentlemen, very much. The gentleman from Pasco, Washington is recognized.
Thank you, Mr. Chairman. Appreciate that. And thank everybody for being here. It sounds like a work in progress that we're working to perfect the process we use, find that balance of stopping terrorism, protecting our country, but also protecting the constitutional rights of American citizens, which is a very important aspect of this. So I appreciate that your hard work, everybody's hard work on this. Mr. Nadler, and it's my criticism of myself, but I was trying to follow your explanation to Mr. Sessions, your example that you were giving about when things kick in and when there's a concern that you're raising. And could I just ask you to, for my benefit, to lead me through that again?
Sure. Okay, under the bill, the warrant requirement applies only to fully predicated official investigations. The Department of Justice guidelines outline the steps in an FBI investigation. From the first tip to a full predicated criminal investigation. An investigation starts with any tip or lead, that somebody told them something. The guidelines say the first thing the FBI should do is search the database, which includes 702 information. Thousands of these searches occur every day. This builds, the search, this builds to an assessment. It's still not going for an indictment, but developing the case, an assessment of how well, what kind of case do we have here. And still unrestricted access to 702 under this bill. After the assessment, only then when the case is fully developed in the assessment phase, then they open an official investigation, which is then a predicated investigation, and then the rule in this bill applies.
Then the warrant is required at that point.
Yes, yes.
But prior to that point, then there's no.
Prior to that point, there's no warrant requirement.
But there's also no action taken either, is there?
Well, depending how you define action. I mean, no one's arrested. Well, no one's arrested necessarily, probably. But on the other hand, if the action is invading someone's privacy in the sense of reading all kinds of things about him or said by him or her, there could have been thousands of things taken. Starts off with looking at the tip, with getting a tip, and then they first search the database, including the 702 database, and they find out God knows what about this individual, and
Okay, so I think I understand. At some point, the warrant is necessitated.
Yeah,
Just
although the
determination of
FBI
what-
told us that this is, in fact, Mr. Schiff in the Democratic conference this morning, I think it was, said that in 2016, there was only one Section 702 warrant like this, so it's not a big problem. From my point of view, that tells me how rare it is, and all the Section 02 use occurs before the predicated, and that's why we need a warrant requirement to kick in earlier.
If I can just
Please
explain.
do.
'Cause in 2016, there was only one case where there was a query unrelated to a national security case, and the evidence was actually used. Because there was no warrant requirement, it didn't matter at what stage of the investigation. But I think that tells you that we're not talking about a tremendous number of non-national security cases where a query leads to evidence that leads to actual use in court. And the safeguard that's put in place for those queries that are done prior to a formal opening of investigation is you can't use it in court if you don't get the warrant. So if the whole idea here, I think, is to prevent fishing expeditions. So I have a criminal case against someone, and I want to see what else might be out there that I could use against them, and then I use it in court against them. This basically says, in the non-national security environment, you can't use it in a non-national security case unless you've gotten a warrant. And, I mean, you can go beyond that and say you can't use it, period, or you can't even do the search period.
At what point do you make that determination?
Well, and the other piece of this, which is hard to talk about in the abstract, is the requirement for the warrant has to be put in place in such a way that you don't prevent FBI and intelligence community personnel from doing the kind of searches we need them to do. Because let's say, for example, I've got a money laundering case that also involves a potential terror link. And if you make the warrant requirement too broad, you either discourage the intelligence agencies from doing the query you want them to do, or you allow them to do it, but then you have to litigate in court, was this part of the money laundering half of the case or part of the potential terrorism case? So part of it is it's got to be workable and not chill the kind of national security searches we want done.
Comment. I think that Mr. Schiff, in the first part of his remarks, really put his finger on one of the major issues here. Do you consider the person's Fourth Amendment privacy rights invaded only if, after his phone calls were tapped and read and so forth, only if that is used in court? Or do you consider that we should stop the searches and the listening to what he said in court, to what he said, even if ultimately that information is not used in court? That is, I think, one of the keys to this question here.
Okay, thank you. I think that helps a lot. I appreciate the clarification. So this isn't obviously a court hearing. We don't always ask questions that we know the answer to prior. So I wanted to ask a question that will be very helpful. I've heard from several sources that this legislation was put together with the strong influence from the agencies involved, and that the committees of jurisdiction really didn't have a lot to say. So I would just like to ask, what say you to that kind of comments and criticisms that are out there?
Well, I'm not aware of anything that DOJ or the FBI have demanded that we put into this bill. We have worked with all of the agencies in the IC to ensure that it's whatever is in the final product and gets signed into law by the president can actually be implemented. So, but Mr. Newhouse, I mean, we've been involved in this. Our staff attorneys have been working with the Senate. We've been working in a bipartisan manner with Mr. Schiff's attorneys on this. So I am not aware of anything that the DOJ or FBI demanded or forced onto us. And in fact, had they done that, I would have rejected that fairly quickly.
Would the gentleman yield?
Absolutely.
Yeah, because I do want to give, there's been a lot of work now, and I think it happens a lot of times in committees. A lot of work that was done in Judiciary Committee and in Intel Committee, that at the end of the day, you're coming together with two committees, and this is what the rules, we're merging these bills. We're getting, and there's some things that we liked in, maybe in Judiciary, and they liked in Intel that I liked on both sides, that are not, they're not blowing together. I think one thing, though, to think about from a perspective of DOJ in particular, and I can't speak from the Attorney General standpoint because I had conversations with him and his staff, they came to us, they were at this line saying, we don't, frankly, don't want to move. I get their understanding. They have a setup of their version of how they protect national security. But what happened was they did move. They did come forward and say, we understand this and from perception and reality and everything else. So I think when you look at it, there was actually, if there's anything from the DOJ, we did see some movement. Would I probably like to see maybe a little bit more understanding? Yes, but that's the way this issue goes. I think the interesting thing is, from the pros perspective, both committees have worked hard at this, and this committee is doing its job as well. The floor will have its say on Thursday, but I think there was movement from the administration level to say, but again, taking it a step further, any step further in this, you do then run the risk of what the 9/11 Commission said, was you getting into siloing and moving out information that doesn't need to be there. That becomes a concern as well. So you have to look at this in that balance. So I just wanted to give input from what we've had in the chairman and the ranking member from Judiciary and others, that we've had these discussions. Can we disagree about this? Yes. But there were movement on all sides here. Is there input and strong opinions? Yes. You're going to hear more strong opinions. I respect my friends from Texas and Michigan who are going to have their opinion. We just disagree. And I think, but in this process, there was no, at least from my perspective on it, a thumbprint that said this is the only way, and especially when you saw the DOJ move and still give us something and not get into the silo, I think that was a positive. So with that, I appreciate you yielding, and I hope that clarified at least a little bit of what we've seen in the past.
Thank you, Mr. Collins. Not to suggest you don't work with agencies on putting together legislation. Absolutely, we do that. But
I would only add that was my experience as well, that all along this process, and we knew obviously the sunset date was coming up, we would confer with the IC and say, what about this provision? What if we did it this way? What impact would that have on the operational integrity of the program? Can you live with this? Can you live with that? There were things that I proposed that didn't end up in the bill. There were things that the chairman of our committee proposed that didn't end up in the bill. There are things that Mr. Nadler proposed that didn't end up in the bill, and I'm sure the same is true of Mr. Goodlatte. And I don't think there was ever a situation where the IC said, tried to dictate terms, but we tried to understand what reservations, concerns, et cetera, they had and accommodate them, and similarly with the privacy community. So I do feel there's been consultation, although none of us got everything we wanted by any means.
I would, that may very well be true for the Intel Committee. I cannot testify to this from my own personal experience. During much of this, I was busy campaigning for ranking member.
Successfully.
Successfully, but very intensively, and it was taking up the time. But, thank you. But I am told by our staff that they reached a point when the Intelligence community, or maybe the FBI, concluded that we weren't going to, we meaning the Judiciary Committee, Democrats and Republicans, not distinguished here, that the Judiciary Committee was not going to go further, and the Judiciary Committee was cut out from all further negotiations from that point in the development of this bill.
Well, Mr. Chairman, I'll yield back my time, but I do appreciate, like I said before, all of your work on balancing national security as well as protection of constitutional rights of American citizens, and thank you very much. I yield back.
Thank you. Gentlelady from Wyoming is recognized.
Thank you very much, Mr. Chairman. I actually have the opposite concern as my friend and colleague from Georgia. I'm worried we may have actually pushed and moved a little bit too far in this bill, but I want to thank very much Chairman Nunes and Mr. Schiff for your work on this. And I think in particular, you've been trying to do this work in what is a very politicized atmosphere and where there are very serious and legitimate concerns about the operations of the DOJ and the FBI. And I think that you've done an admirable job at making clear that we've got to keep those separate from Fisa 702. And I also think it's hugely important all of us here in this body remember and recognize that we will be held accountable If we end up in a situation again where we have put those walls back up, where we have made it tougher for law enforcement, for our intelligence community to connect the dots, we've got to understand that that is an obligation, a responsibility that we're taking on ourselves. And I think that we've got to make sure as we go forward here that we're not talking about something that's an academic exercise. It's a very serious business of balancing privacy rights, which are legitimate, with the national security of the nation. But because we have been through 9/11, we cannot pretend that we're ignorant as to what happens when we do not connect the dots or when we as a body make it more difficult for those who are tasked with the job of keeping us safe to do their job. So I support this bill. As I said, I would have supported it without some of the movement that we've seen. But I commend you very much for the bipartisan effort and for the way that you put it together in a very difficult atmosphere. And I look forward to speaking on it too tomorrow, and I'm very hopeful that it will pass the House, and I believe it will. Thank you, and I yield back, Mr. Chairman.
Thank you very much. And gentlemen, thank you for your testimony. You're excused. Appreciate you coming back after the vote. If we could, we'll have our next panel come up, Mr. Amash, Mr. Himes, Mr. Fahrenhold, Mr. Davidson, and I believe Ms. Laughlin is on her way, so we'll have her seated at the table when she arrives as well. I want to thank you gentlemen for coming up to testify. If we could, I'll just go in the order that I read the name. So Mr. Amash, we'll begin with you, and you're recognized for whatever opening statement you care to make.
Thank you, Mr. Chairman, and thanks to the members of the committee. I'm going to briefly explain what my amendment does. I have a one-pager here. Many of you may have it, but I want to make sure that those who haven't heard it will get an understanding of this amendment. And Section 702 as well. So Section 702 of Fisa authorizes the surveillance of foreigners outside the U.S., but it has been used to warrantlessly collect the communications of Americans. With little oversight, this data can then be searched without a warrant and used for a wide range of purposes, including criminal prosecutions, unrelated to foreign intelligence. S-139, that's the underlying bill, reauthorizes Section 702 without addressing any of these issues. The USA Rights Act, which is the amendment I have offered, it is a Senator Ron Wyden Rand Paul bill, and it's been introduced here in the House by Representative Lofgren. The USA Rights Act reauthorizes Section 702 to allow the intelligence community to do its job and conduct foreign surveillance, including on terrorists, with basic reforms to protect Americans. So there are collection reforms. It prohibits the government from collecting communications that it knows are fully domestic and prohibits the government from intentionally collecting communications which aren't sent to or from an actual surveillance target, which tends to result in substantially more Americans' data being collected. It prohibits the reverse targeting of Americans, where the government targets a foreigner's communications largely for the purpose of sweeping in an American's communications. It requires approval from the Foreign Intelligence Surveillance Court for the government to force American companies to assist with Section 702 surveillance, and requires the assistance to be necessary and narrowly tailored. It has backdoor search reform. It requires a warrant to search the government's database of Section 702 data for communications to, from, or about an American. It has use reforms. It ensures that our foreign intelligence programs are used for foreign intelligence purposes by preventing the use of warrantlessly collected Section 702 data against Americans in court, unless the proceeding involves preventing terrorism, espionage, use of a weapon of mass destruction, incapacitation of critical infrastructure, foreign cyber threats, or threats to U.S. personnel or our allies. And it strengthens the existing requirement that the government give due notice to defendants when Section 702 data is used against them in court. The amendment has broad, nonpartisan support. The ACLU supports it. FreedomWorks also supports it. The NAACP supports it, and so does Campaign for Liberty. The underlying bill allows the government to collect massive amounts of Americans' communications.
It expressly allows those communications to be warrantlessly searched to find information on Americans. And it expressly allows the government to prosecute Americans using this data for crimes totally unrelated to foreign intelligence. And I think Mr. Nadler has laid out very nicely why the warrant requirement, the alleged warrant requirement in the underlying bill is not effective. It doesn't operate in most circumstances. The USA Rights Act ensures the government can conduct surveillance of foreigners while preventing the collection of Americans' communications when they aren't in contact with terrorists or dangerous foreign agents. And it requires a warrant to search through the data for information on Americans. This is a bipartisan amendment. As of this meeting, we have 41 co-sponsors. I think there are more who tried to be added even at the last second. It's very bipartisan. It has broad support. I think when we talk to various members, all of them agree. I don't think I've run into any members who think that we shouldn't require a warrant to search on Americans. I think the majority of members are just trying to figure out whether there's a requirement in the underlying bill or not. And as Mr. Nadler has laid out, there's not any real requirement in the underlying bill. What this bill really adds that's important is that warrant requirement to search on Americans. Thank you, Mr. Chairman. I yield back. Thank you very much. I'll exercise chairman's prerogative because I know we have a number of you that have amendments. I don't know if you all do or not. But if that's okay with everybody, I want to go to Ms. Lofgren, excuse me, next for whatever amendment.
Thank you, Mr. Chairman. And I'll be brief because my colleague from Michigan has covered his amendment quite well. I'm here to speak in favor of the other amendment that's being sought, which is the Poe-Lofgren amendment, which ends the so-called about collection, which the NSA supposedly voluntarily gave up last year only after the Fisa court twice told them it was unconstitutional. We think it's important that that about search, the prohibition on that be codified. The underlying bill, the HPSI bill, actually for the first time codifies it. I don't know that it's constitutional just because you codify it, but certainly that is the wrong direction to go when we're defending the Fourth Amendment. The intelligence community paints the decision of the court as a technical limitation. I guess technically that's true because it couldn't comply with the Fourth Amendment technically or any other way. I do think that the requirement for a warrant that is outlined in the Poe-Lofgren amendment is very important, as my colleague from Michigan has explained. These two amendments are consistent with each other. There's slightly variations on a theme, but I came here primarily to speak for the Poe-Lofgren amendment. I just want to talk with, and we are constrained on talking about it because this is obviously not a classified setting, but the so-called incidental collection, I hope that we'll all recall Admiral Rogers' answer to the question of the scope of what we were talking about when we had our classified briefing. And when you have a small percentage of a very large amount, it's a very large amount. And so that's why it's really important that we get this right, that we protect the Fourth Amendment rights of Americans. And Mr. Poe and I are co-chairs of the Fourth Amendment Caucus here in the Congress of the United States, and that's why I was proud to co-author the amendment with him. And with that, I thank you very much for allowing me to speak, and I would ask unanimous consent to put the remainder of my comments in the record.
Thank you very much. My good friend from Texas is recognized. Next, couldn't have had a better introduction. No.
That's correct. Thank you, Mr. Chairman, and thank the committee. I support both of the amendments. I'll speak specifically to the one that Ms. Lofgren and I is more narrowly focused. And I won't talk about the about situation because she's covered it. Some of you may know I'm a former judge. I signed search warrants for 22 years, and I denied signing
search warrants for 22 years. 702 is a unique situation under law. First of all, you got secret courts issuing secret warrants that are never made public unless one of those secret judges allows it to be made public. I understand the reason, national security. And under Fisa, the primary purpose is to go after terrorists and agents of foreign states. The purpose is not to go after Americans. But Americans' information is collected incidentally after going after the targets. And this is a unique situation under Fourth Amendment law because normally there is a search and then there is a seizure. Search based on probable cause, signed by a judge, and then based on that search, evidence is gathered and then used. Under Fisa, the situation is completely backwards. There is a seizure first, and then there is a search. And there's actually two searches. One is on the data, how many times something is queried. Justice Department calls it a query because it's a search. So there's two searches. And what this amendment does is require that before government starts going after the incidental matters of Americans that it's already seized, that they get a search warrant that states probable cause. We have asked the Justice Department, Judiciary Committee, Mr. Goodlatte, has asked the Justice Department, how many times has this happened where Americans have been queried and searched? Justice Department won't give us an answer. They say they can't. I candidly don't believe that. I think they can get somebody from a geek from Best Buy and type in some type of program to get that information, but be that as it may. And I think they're waiting this out because we're going to find out, I believe, that it's a lot of times that they are looking through data on Americans, not the purpose of Fisa. Go after the terrorists. Go after them, get them, try them. Let me try them. I don't know. But the point is, this law is being used to go after Americans. And it's not on terrorist or national security issues, Mr. Chairman. You may have Bobby Oglethorpe, notorious criminal in Texas, and he is in this system of metadata. And so the FBI looks and sees how many times his name pops up. And then they go in and investigate him for IRS violation or a bank robbery or cattle theft. You have cattle in Oklahoma. Indeed, we do. Yeah, a few that we hadn't gotten in Texas. And anyway, that has nothing to do with the purpose of Fisa is to go after terrorists and then use that information. We don't know how many times that's being done. And so let's just get back to the basics. Search warrant requirement when you start looking and going after Americans under 702 of Foreign Intelligence Act. And I'd like unanimous consent to submit for the record my entire statement. Without objection. Thank you, sir.
Thank you. Mr. Himes from Connecticut.
Thank you, Mr. Chairman. I appreciate this opportunity to offer two amendments to the FISA Amendments Reauthorization Act. My first amendment pertains to what we're talking about here, backdoor searches. And it simply says that in addition to the probable cause-based order requirement for open criminal investigations unrelated to national security, that in contexts short of open investigations, following up on a lead, anything short of a criminal investigation, it would require the government, the FBI in particular, which is a whole other issue, but the FBI in particular, to make an argument of what's known as reasonable articulable suspicion to a judge and get some Fourth Amendment process accomplished in a context right now, which as Mr. Amash points out, there is no Fourth Amendment process. My second amendment simply clarifies something related to about collection. It says that if about collection resumes, it will only apply to upstream collection. Now let me just take a little bit of time on my First Amendment, because we're talking about
databases and mass surveillance, let's boil this down a little bit. The government has a massive database of, Mr. Chairman, your kids' photos, Mr. Polis's texts to his friends, Mr. Woodall's, maybe your prescriptions, that we don't want. We don't want this database. And in fact, we certified to the Fisa court, or appropriately the Department of Justice certifies to the Fisa court, that they don't want this database. They are not using 702 to target Americans. But they have this database because we can't help but collect American information as we seek information on non-US persons, the bad guys, foreigners. So we've got a database that we don't want full of American information. And we're arguing over under what terms the FBI or the government should be able to access that information. It's an interesting argument because if we didn't have this database under the Constitution, the FBI would be absolutely required to seek a warrant to rifle through your emails or my texts or Mr. Amash's photographs. But they're not required due to the fact that this is legally, inevitably, but legally collected. There is an argument, Mr. Sessions said compromise. There is an argument that I think Mr. Amash articulates that there should be no compromise, that just because we have this database that we don't want doesn't mean that it shouldn't be subject to full Fourth Amendment protections, that any law enforcement officer who wants to go through your text or my photographs or your prescriptions should get a warrant to do it. I am actually proposing a compromise, which is that in the case of an investigation, get a warrant. If the information is going to be used in court, get a warrant. But if you're not, if you're simply following up on a tip, Mr. Cole, if a state police officer decided that you looked a little suspicious and convinced an FBI agent to run a query on you, and now we have an FBI agent looking through your emails and your photographs, at a minimum there ought to be some Fourth Amendment process, that FBI agent going before a judge and not even asking for probable cause, but saying, I have a reasonable, articulable suspicion. That's a compromise. The base bill says that only in the case of a fully predicated investigation, which the FBI will tell you is actually a pretty small percentage of the kinds of looking that they do, only in that case would there be Fourth Amendment process. My amendment falls short of where Mr. Amash and Ms. Lofgren would have us be, and I respect where they're coming from. It's a compromise. It says that you got to do some Fourth Amendment process. You simply need to go before a judge and articulate reasonable suspicion. Thank you. I yield back. I thank the gentleman. The gentleman from Texas, Mr. Farenthold, is recognized.
Thank you very much. I have my own amendment, but with the chair's indulgence, I'd like to speak for just 30 seconds on the Fourth Amendment in general. The Fourth Amendment protects us from unreasonable searches and seizures. It doesn't protect us from unreasonable search and seizures that are used in court or used in a criminal investigation. If you look at the history of the Revolution, the king would send his troops in to rifle through your desk. And there are all sorts of things that search may render that may never be used in a criminal prosecution, but you wouldn't like somebody else knowing. You might not want the government knowing what doctors you were talking to. You might not want them to know who your banker is. Nothing illegal about any of it, who your priest is. And all that data is available. So I am co-sponsors of these other amendments, but I've got one of my own that's substantially more narrow that I think we can maybe all agree on and move forward on. Like I said, I see a lot of problems with the act and have lots of reasons to oppose it. The massive store of data we have on Americans would make the Founding Fathers cringe and J. Edgar Hoover proud. Although my amendment won't begin to address all the constitutional and ethical problems with this legislation, I hope it puts forward at least one small fix we can agree on. Section 102 of the Fisa Amendments Reauthorization Acts establishes the conditions under which information concerning a United States person acquired under Section 702 may be used as evidence against a U.S. person in a criminal proceeding. The first option, which is very reasonable, is the FBI obtains an order from the Fisa court to access the information. In other words, they get a warrant. They probably need to get a warrant sooner, but
again, this is the compromise language we're working on. What's more troubling, though, is the second option, namely that the Attorney General can make a determination that either the criminal proceeding affects, involves, or relates to the national security of the United States, or involves one of a rather lengthy list of crimes, including death, kidnapping, serious bodily injury, cybersecurity, etc. This is the loophole that you can drive the truck through that Mr. Nadler was speaking about earlier. But what's troubling about the second route, besides the crimes that it applies to, aren't directly related to national security, is the bill also gives the Attorney General's determination that it's okay to do this, says it's not subject to judicial review. There's absolutely no reason the AG's determination in these criminal cases should not be subjected to judicial review. This provision, as it's written, violates two fundamental principles of American government: the separation of powers, that is, the appropriate checks and balances between co-equal branches of government, and the process for the protection of Americans accused of crimes by the government. There's no reason that the FBI and the Attorney General should be able to make these determinations without being checked by the judicial branch after the fact. There isn't even a plausible national security emergency argument here, since we're not talking about responding to immediate threat, but rather about what evidence is going to be admissible in a likely slow-moving criminal trial. My amendment offers two simple fixes. First, it establishes that the Attorney General's determination for the purposes of using 702 information in a criminal proceeding against U.S. Persons, it should be and shall, and we use the word shall be subject to judicial review. That makes, that says it is reviewable. Second, it requires the Attorney General to produce written documentation to accompany his or her determination and to report on the determinations he or she makes to Congress each year. Having some kind of paper trail will allow criminal defendants and privacy advocates to challenge these determinations, and will give Congress information we badly need in able to determine how this provision is being used. In other words, it'll allow us to keep an eye on the Justice Department and ensure that it handles the power it has under 702 responsibly. I know this is only a small amendment, but it's something that I think makes the bill substantially better and something we should be able to agree on, and I thank you for your time. I thank the gentleman for his testimony. Mr. Davidson.
I thank the committee. Thank you, Chairman, for the time, and I appreciate this process. And I hope that the bill that we get to vote on is subject to the same level of dialogue and discussion. And I appreciate the work that the committees of jurisdiction have done to try to negotiate or pre-negotiate a deal. But frankly, the people of each of our respective districts are supposed to have a voice in this process. And so I hope that we get to vote on all these amendments, or they're all ruled in order. I certainly appreciate Mr. Amash's and the Poe Lofgren amendments, having looked at them in more detail, and I've been encouraged by some of the other discussion that I've heard here. So I've got 5 amendments and essentially broke several of the components of the USA Rights Act out into key provisions. We've talked extensively about backdoor searches, and this, no need to continue there, but we've talked extensively about FBI reporting requirements. Frankly, the CIA and NSA have prohibitions in reporting, but we would like to know how often this database is queried, and I think that's a reasonable request. It's a pretty easy feature on Google. I think if we don't have a way to look at it rearward looking, it really wouldn't take a lot of coding to be able to look at it in the future at some date certain. We should codify the ban on about collections. We've talked a lot about that, but it's already been ruled unconstitutional, and I think rather than saying, hey, go to a couple people in a totally classified setting and get permission to turn it back on, that we, the people, ought to have a voice in when that is turned on, because it is called the foreign surveillance that we're talking about, not for American citizens. And then we've talked a little bit about reverse targeting, but we need strong protection to make sure that this isn't purposely being collected on Americans. And so these other amendments have talked a lot about that, so I'll spend just a little bit on the Fifth Amendment, which is actually Amendment 5 of the proposal. But this would require the Director of National Intelligence to submit an annual report to Congress
on any disciplinary actions taken against an employee of the United States government related to mishandling information acquired under Section 702 of Fisa. And when you ask, well, they would never do that because there's such strong prohibitions. Well, okay, you're telling me that you don't have humans there. We have humans that work there. So surely someone didn't get trained adequately. Maybe they just didn't get trained adequately. There's no malicious intent, needed to be retrained. Well, someone was trained properly, but they keep doing things they shouldn't do, so they were disciplined. They were given a written counseling statement. Maybe someone was terminated, and perhaps, since it's against the law to abuse this access, perhaps someone was actually prosecuted. This would say, we're going to give you the information and collect it. So I think it's an important safeguard, and this is one of the big things. We don't have a very closed-loop system on this massive amount of discretion that's given. We have a lot of tools that say, we're going to do this, we're going to do that, but even after the fact, we don't check to say, well, did you actually comply with that? And so I think this is an incredible, important theme, and I hope we get the chance to vote on these other amendments, including mine. I yield. Thank the gentleman for his testimony. As the acting chair, I really don't have any questions, so let me go first to Mr. Woodall.
Thank you, Mr. Chairman. Judge Poe, I wanted to ask you, since you have done this for the better part of your career, at its core, as I've listened to the Judiciary Committee and the Intelligence Committee argue about this, the question is, you have actionable intelligence on that kidnapping. I'm an FBI agent. I'm not working national security. I'm working kidnappings, and there's a young child that's been abducted, and I have reason to believe I might be able to access this collection of data and make a difference for that family and that child. And why in the world, folks would say, if we have the ability to make that difference, why wouldn't we make that difference? My expectation is, as you've denied searches time and time again, you have an answer to why, even though the facts may be compelling in a circumstance, there's an overriding concern that needs to be served.
If I understand your question, are you asking why wouldn't we get a search warrant?
I'm asking
why wouldn't the FBI agent get a search warrant?
Why would you delay the FBI agent who's investigating that kidnapping by asking them to go through that long process? They just want to search. They just want to search to see, as the clock ticks, whether or not they can make a difference in this particular case. And the Attorney General would say we need to act with haste in that case. As the judge, you would say.
And you're not talking about a terrorist case.
I'm not talking about.
All right. The Fourth Amendment. The premise is that there will be a search warrant. Probable cause, get a search warrant, and then you search and seize. But there are exigent circumstances to the Fourth Amendment. There are numerous exigent circumstances. The high-speed chase is one of those. Following somebody into a house. The situation that you outlined, I think probably, just based on the limited information, that's exigent circumstances for an immediate, to go around the probable cause search warrant requirement. So exigent circumstances still come into play, but the rule should be you get a probable cause warrant before you do the search. So that would maybe an exception to that.
And Mr. Amash, is that true of your language, that the exigent circumstances, exceptions that would be available for any other case, not dealing with 702, would be available in this circumstance? You're not placing further restrictions on the 702 data than you would place in a normal civilian criminal case?
Correct. That's, and without speaking to my opinion on particular exceptions to the Fourth Amendment that have been outlined in Fourth Amendment jurisprudence, typical Fourth Amendment jurisprudence would apply to this case just like to any other case. So we're creating a baseline protection that is consistent with the Fourth Amendment, and there are courts that have decided that there are particular circumstances that require exceptions. I'm not speaking as to whether I agree with that, but I'm saying the courts would apply them the same way, whether it's a 702 case or another case.
To Ms. Loughran's point about trying to make sure about collection doesn't come back after courts have pushed it away, it sometimes confuses me when we talk about constitutional protections, because those exist whether or not we meet in the Rules Committee on a Tuesday afternoon or not. I don't need an Amash amendment or a Nunes
bill to protect my constitutional rights. Those rights are protected inherently. If I talk to the Justice Department, that's the tale they will tell me. This isn't a constitutional issue. This is an issue about where you and Mr. Amash and Mr. Poe want to be on privacy concerns general, not a constitutional issue. Is that a fair case to make?
Well, I'm not sure what the question is exactly, or whether I misunderstood your question.
Well, let me just, what I want to know is, do you believe that where we are today in law will ultimately be struck down by a court somewhere because it is a bridge too far, and you just want to go ahead and codify that solution today? Or is it that we're not talking about constitutional issues at all? We're just talking about personal preferences in where to draw the line for privacy.
Well, I would say that the Supreme Court is moving more in the direction of protecting privacy because they're having to deal with modern cases that involve technology. And I think that actually Fourth Amendment jurisprudence is moving in the direction of protecting more privacy. But I would also add that we take an oath to support and defend the Constitution. It's our job to defend the Constitution. We're not supposed to leave it to the executive branch or the judicial branch. When we think that something is wrong, that there's a violation of people's rights, we have to take action. And it's not right for us to kick it to some other branch of government. And this is a case where it's very clear-cut, in my opinion. The Constitution, the Fourth Amendment, is there to protect people's rights, to protect us from unreasonable searches and seizures. We have a new world today where technology allows our data to be spread around the world, our information, and we have to protect that information. It's our job to act. We have the ability to do it, and we put together a good compromise. The Amash Amendment, or the Poe-Lofgren Amendment, or some of these other amendments that have been talked about, have offered good compromises that will protect people's rights while still allowing us to go after foreign terrorists. And I think that's our job, and I hope we can accomplish that task this week.
Mr. Davidson, you broke those down into individual components. Is there a hierarchy of your amendments in terms of where you think the most serious threat lies versus where a serious but less serious threat lies?
Well, I think the threat is exactly, what you highlighted there. It's to our Constitution, and we do inherently have a duty to protect it. That's the oath we swore, and I couldn't agree more with Mr. Amash's response. But to illustrate this is what we've done with Fisa. Because it's electronic data, we've basically, when the United States Post Office is in possession of letters or mail, the jurisprudence on that's fine, clear. We don't just go opening your mail. We do that with warrants. But because it's electronic, we've said, oh, well, it's incidental, we just collect it. But imagine if you would say, well, we're going to just open every single piece of mail, every FedEx package, UPS package that goes through, and it's paper, but we're going to scan it in and digitize it, and it's all going to be in there. But trust us, we're not going to really touch it unless it's really important. That's really what Mr. Poe was highlighting, is we're going to seize it before we authorize the search. And so that's effectively what we've done. And I feel that technology and the practice of this has gotten ahead, out of sync with our duty to protect our constitutional rights. And so I think the right thing here would be that we take that into account. And frankly, I think that the amendments that I've proposed, or the amendments Mr. Amash, Mr. Poe, Ms. Lofgren have proposed, move that back into a more consistent framework with our Fourth Amendment.
And finally, Ms. Lofgren, to Mr. Davidson's point, technology is moving quickly, and the chair and ranking member of the Intelligence Committee, when they were here earlier, made the case that we're all protected from about collection today by the courts, but there may one day come a time where technology allows about protection, about queries in a way that we are all protected. Does your language prohibit what is anticipated to be a technological solution to the problem the court identified, or does your language allow that one day, as technology changes, we may still be making these queries, but in a way that satisfy your concerns?
It's important to note
that what's being collected here is not the so-called metadata. It's all of the content. And because of the way technology works today, you make a phone call, that's on the internet, that's captured. Every phone call, every email, I mean, it's all just data. And the about provision expands the amount of data that can be done. What we're saying is you need a warrant. You need a warrant. And, you know, I just want to go back to the constitutional issue because it's been a problem in modern times, not just this Congress, that we have outsourced constitutional determinations to the judicial branch. God love the judicial branch, but we have our own obligations, and we may be able to move faster in some cases than they can. And I'll just give you an example. It has nothing to do with the case before us. You have certain doctrines that go back a long ways. For example, if you're in plain view, you have no expectation of privacy. We all agree with that. Well, did we expect that there would be a camera on every corner and that every image of every American would be captured, put in a database, and crunched so that the government could know where every American was at every moment? Is that covered by the plain view doctrine? That's something we need to think about.
One of our chairman's favorite quotes on the wall down below is, "The greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning but without understanding." It's hard as the technology outpaces so much of our understanding, so much that we can't discuss in an unclassified setting, not to fear being one of those well-meaning men or women of zeal. I thank you all for being here, Mr. Chairman. I yield back. Thank you, gentlemen. Gentleman from Massachusetts recognized.
I just want to thank everybody for being here. I want to thank you for caring about protecting people's civil liberties and their privacy, which I think is a bipartisan concern, obviously. Clearly, some people are satisfied with the compromise, and some people are not. I'm personally am not, and I think we should save everybody a lot of time and make all your amendments in order. The idea that we're going to kind of have this debate here in the Rules Committee and decide, you know, which one should be made in order doesn't seem to me to make a lot of sense. I mean, on an issue like this, I think, you know, everything that is relevant and germane ought to be made in order, and that's the way I'm going to vote. So I want to thank you for being in here. I yield back my time.
Thank you, gentleman. Gentleman from Texas.
Thank you, Mr. Chairman. Mr. Wash, do I understand that this amendment that you're offering today is substantially similar to amendments you have offered in the past?
It's substantially similar to an amendment I offered to a bill that we didn't proceed on before the Christmas break, but it is identical to what Senator Wyden has offered in the Senate and what Rep. Lofgren has offered here in the House.
But have we not voted on your amendment?
We have not voted on this amendment, no.
Very well. We may get a chance to. Thank you for bringing it to the committee. I appreciate it. I yield back, Chairman.
Thank you, gentleman from Colorado.
Thank you. I sure hope that we get a chance to, because while some have described the underlying bill as a compromise, I don't really think that's the case. In fact, not only does it not take any of the steps we needed towards reform, but it actually codifies the ability of the government to access the content of emails and telephone calls without a warrant. It codifies the word about collections, which refers to NSA searching through the internet traffic to collect not only communications to or from an intelligence target, but also those that simply mention an identifier used by a target, which could just be the name of a city or a country, like United States, which has also been declared unconstitutional in prior cases. It fails to consider my concern and the concern of many others that the government's use of Section 702 against United States citizens in investigations that have nothing to do with national security is not addressed. It creates a unworkable optional warrant mechanism for some crimes and yet not for others, meaning that some criminal investigations require less due process somehow. Other crimes might go uninvestigated. I don't think it's well thought through at all. These enormous flaws also perhaps result from the fact that this version only came from the Intelligence Committee, effectively bypassing the Judiciary Committee. I signed a bipartisan letter demanding that FISA be handled under regular order. I'm proud to be a co-sponsor of the amendment along with Representatives Lofgren and Amash that would provide a better path to reauthorize FISA, keeping our country safe and protecting our Constitution. As was indicated, it was based off the USA Rights Act. It ends backdoor searches, ends reverse targeting, bans the so-called about collections, and strengthens the oversight of FISA courts. I hope that that is made in order, and my first question is for Mr. Amash. In the previous panel, and I think you were here, Mr. Nadler and Mr. Nunes talked about how the warrant problem was addressed or fixed. Do you agree that under the underlying bill, warrants are required, and can you kind of address your concerns about the process in the underlying bill?
In most circumstances, under the bill, the underlying bill, warrants would not be required in the vast majority of circumstances. And Mr. Nadler laid it out very well. There are only a few circumstances in which we could even imagine a warrant would be required, and those would not be the typical situations that we'd be trying to protect against. So we're worried about the government coming in and searching things at earlier stages, even before we get to the end stages of a criminal investigation. So Mr. Nadler laid it out, I think, twice to this committee, and I think he stated it well. And Mr. Sensenbrenner has said the same. He sent a letter today and explained the same thing, and is very concerned. I think in his letter he said, the warrant requirement applies only to fully predicated official investigations and not to the hundreds of thousands of searches the FBI runs every day, just to run down a lead or check out a tip. The FBI admits that they will almost never be forced to use a warrant to access your email or phone calls. And that's from a letter from Mr. Nadler and Mr. Sensenbrenner.
Would you say it almost creates that optional warrant as a cover for the fact that it doesn't need warrants? I mean, is that it seems so unworkable? Is that what is?
I don't want to speak to anyone's motivations in how the bill was drafted. I would say that I believe that it attempts to present a warrant requirement on its face to provide people an opportunity to say they voted for something with a warrant requirement. But the warrant requirement, in fact, is not a warrant requirement. It would operate in very limited circumstances.
And Ms. Lofgren, could you talk about some of the problems with the about collections language and how that might be overly broad?
Well, I think Mr. Amash has covered it. The about collection does not rely on the communication between a foreign suspect and American. As you recall, prior to 2008, you couldn't do any of this. It was when we did 702 that expanded the warrantless search that this became a problem, and the incidental, so-called incidental collections came into play. The about collection further expands that, and I think that's very problematic. We had a huge argument a few years ago about selection terms, but that's really absent here, and so it broadly advances the capacity for the government to collect enormous volumes of data that is very detailed and is the content of communications, both verbal through telecommunications as well as email, text messages, videos, and the like.
Thank you. And I want to point out that the base language has united in opposition not only privacy and civil liberties groups, but also internet and consumer groups, as well as technology companies and job creators across our country. So it's problematic from both the business perspective as well as from an individual liberty perspective, as well as from a consumer perspective. I hope that the Lofgren and Amash amendment is made in order and that the House can remedy the flaws in the bill and still pass an underlying bill that can protect our national security. And I yield back.
Thank you, gentlemen. Looks like we've had a mass exodus, so the gentlewoman from Wyoming is up next. No question. How would you like to proceed? Okay, we'll dismiss the panel, and thank you all for your testimony. Very helpful. Nothing like the original, though, I'm sorry.
When it came to debating tribal sovereignty issues, I thought you might have not an improvement, but certainly a capable replacement.
Thank you very much. We've now completed the hearing portion, and as we have assumed, our S-139 Rapid DNA Act of 2017, we now close that hearing portion and want to thank members of Congress, Republican and Democrat, who came not only to express their views, but to give us their ideas. This is a very important issue for freedom and liberty in the United States, and want to thank them. I also want to acknowledge and thank a young woman who is an intern in my office, Rose Hartwell from the University of Virginia, who took time to come as part of a college class and be with us today. And I want to thank Rose for joining us. I want to thank my Chief of Staff, the gentleman, Kyle Matus, for his continued insistence to allow University of Virginia students to participate in what we're doing. We also are, I'm honored to have Mr. Michael Quinn Sullivan, who is from Texas, who is visiting today, and I want to thank and welcome him to the Rules Committee. The gentleman, Mr. Gallant, Carl Gallant, also was a visitor today to the hearing. Chair, will now be in receipt of a motion from the distinguished gentleman from Oklahoma.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant S-140, a bill to amend the White Mountain Apache Tribe Water Rights Quantification Act of 2010 to clarify the use of the amounts of the WMAT Settlement Fund, a closed rule. The rule provides 1 hour of debate equally divided among and controlled by the chair and ranking minority member of the Committee on Education and Workforce and the chair and ranking member of the Committee on Natural Resources. The rule waives all points of order against consideration of the bill. The rule provides for that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-54 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
Thank you very much. The gentleman has now gone through Rule 1, which would be S-140, the tribal package. I will yield myself to discuss this for a second. As we have talked about, this will be a closed rule, 1 hour debate, providing 30 minutes to chairman and ranking member of the Committee on Education and Workforce, and 30 minutes to the chair and ranking member of the Committee on Natural Resources. There would be, as always, a motion to recommit, and it would provide us the ability to move forward on this package. Is there amendment or discussion to S-140 Rule Number 1? Seeing none, the vote will now be on the motion from the distinguished gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it. The ayes have it. Gentlewoman requests a roll call vote. The clerk will poll the committee.
Mr. Cole. Aye. Mr. Cole, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Collins. Aye. Mr. Collins, aye. Mr. Byrne. Mr. Newhouse. Aye. Mr. Newhouse, aye. Mr. Buck. Ms. Cheney. Aye. Ms. Cheney, aye. Ms. Slaughter. No. Ms. Slaughter, no. Mr. McGovern? No. Mr. McGovern, no. Mr. Hastings? Mr. Polis? No. Mr. Polis, no. Mr. Chairman?
Aye. And if the clerk could please advise the committee how the gentleman, Dr. Burgess, is
He is not recorded.
The gentleman would please poll the gentleman, Dr. Burgess.
Dr. Burgess? Dr. Burgess, aye.
Thank you very much. Clerk will report the total.
Seven yeas, 3 nays.
The motion is agreed to. Accordingly, the gentleman, distinguished gentleman from Oklahoma, Chairman Cole, will be handling this for Republicans. And Mr. Polis will be handling this for the minority. Chair will now be in receipt of a second motion, rule number 2. The gentleman, distinguished gentleman from Oklahoma is recognized.
Mr. Chairman, I move the committee grant S-139, the Rapid DNA Act of 2017, a structured rule. Rule provides 1 hour of debate with 40 minutes equally divided and controlled by the chair and ranking minority member of the Permanent Select Committee on Intelligence, and 20 minutes equally divided and controlled by the chair and ranking member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. Rule provides an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-53 shall be considered as adopted, and the bill as amended shall be considered as read. Rule waives all points of order against provisions in the bill as amended. Rule makes an order only the further amendment printed in the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in the report. Finally, the rule provides one motion to commit with or without instructions.
Thank you very much. You've heard the motion from the distinguished gentleman from Oklahoma. And is there amendment or discussion to that? The gentleman from Colorado.
Mr. Chairman, I have an amendment to the rule to move the committee, make an order, and give the necessary waivers for the amendment to S-139 by myself and Representatives Poe, Lofgren, Nadler, and many others, number 3, which would mandate a warrant requirement for a search of the 702 database on a U.S. person. It also ends the about collection. This amendment, which has strong bipartisan support, as well as the support of the ranking member of the Judiciary Committee. I would be the first to say this amendment doesn't go far enough. I'm glad the other amendment is made in order. However, this amendment would address a key area of debate on this bill, and I think there's many members on both sides of the aisle who want the opportunity to vote on this simple, straightforward amendment, as well as the more comprehensive amendment, which is made under order under this rule. And I encourage my colleagues to vote yes to allow for a up or down vote on the Poe, Lofgren, Nadler, Polis amendment. And I yield back.
Thank you very much. Is there further discussion? I would, if I could, like to provide information back, mostly for the record, not to in any way diminish the distinguished gentleman from Colorado's respect for his not only right but belief in the amendments that he spoke about. First, there is no Fourth Amendment protection from law enforcement agencies from viewing lawfully acquired data. 702 was lawfully acquired, and the constitutionality of these types of searches have been confirmed by the Fisa court and other U.S. federal district courts. If there is a U.S. person abroad who is a terrorist or spy, there is no reason why the IC should have to obtain a separate order to lawfully view acquired data in national security cases. So, in other words, it completely contradicts the 9/11 Commission report. I would add that the gentleman understands as well as I that each of our members of this body are increasingly finding themselves needing to not only understand the way law enforcement is operating, not just the agencies, but the various components of that, including data and information in SCIF areas, but actually how it all works together, increasingly a complex circumstance. And I want to thank the gentleman. I want to thank the people up to and including Mr. Nadler and Mr. Schiff and certainly others who have taken their time to come and try and advise us, Mr. Amash, Mr. Himes, Mr. Farenthold, Mr. Davidson, Zoe Lofgren, and Judge Poe, but also your devotion and dedication to this. And I will tell you that increasingly our attention to the details of our security matters, the laws of this country, the use of Fisa, and how our law enforcement agencies and intelligence securities use these datas that are collected is important. And I am going to dedicate myself more to the operational issues, and I recognize that I have not been up to date on that. And so I appreciate and respect the gentleman. This has been vetted by what I think are security people who are day in and day out involved in this, and that was why I believe you have seen the gentleman, Mr. Cole, allude to the Amash amendment that would be made in order that we believed going into this some time ago would allow a member to distinguish themselves in understanding an amendment that would be on the full floor to satisfy some of the arrangements. So I do respect and appreciate the gentleman from doing that. I believe what we're trying to do is to push the envelope more by learning more about where members are, by opening up the discussion, and by allowing that debate on the floor. And I appreciate and respect the gentleman and thank him for allowing me to offer my own words in support of the discussion. Is there further discussion? Seeing none, the vote will now be on the post amendment. Those in favor of the post amendment signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Roll call, please.
Gentleman asks for a roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Collins? No. Mr. Collins, no. Mr. Byrne? Mr. Newhouse? No. Mr. Newhouse, no. Mr. Buck? Ms. Cheney? Ms. Cheney, no. Ms. Slaughter? Aye. Ms. Slaughter, aye. Mr. McGovern? Aye. Mr. McGovern, aye. Mr. Hastings? Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 6 nays.
The amendment's not agreed to, the affirmative or discussion. Seeing none, the vote will now be on the motion from the distinguished gentleman from Oklahoma. Those in favor of the motion signify by saying aye. Aye. And those opposed, no.
No.
The ayes have it, the ayes have it. And according, gentlewoman asked for a roll call vote. Clerk will poll the committee.
Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mr. Collins? Aye. Mr. Collins, aye. Mr. Byrne? Mr. Newhouse? Aye. Mr. Newhouse, aye. Mr. Buck? Ms. Cheney? Ms. Slaughter? No. Ms. Slaughter, no. Mr. McGovern? No. Mr. McGovern, no. Mr. Hastings? Mr. Polis?
No.
Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
6 yeas, 3 nays.
The motion is agreed to. Accordingly, the gentleman, Mr. Collins, will be handling this for Republicans.
Mr. Hastings.
And Judge Hastings will be handling this for Democrats. Judge Hastings is not here to ask the question, but the answer is we do not expect any additional meetings this week. I want to thank each of you not only for the attention to the matter, but your participation in today's important hearing. We've now completed our meetings for the week.